Solutions, Bangalore, while speaking on the topic patents and patent filing mechanisms, gave systematic information of patentability, non-patentability, procedure of filing the patents in India, etc. And also given the information that he is also patent holder of so many patents. And really we felt very proud to see one who has practically experienced all this. So thus, with interesting sessions of yesterday, we all are eager to listen today's session. And with this backdrop, I welcome you once again to all of you. Thank you.
Thank you, ma'am. Now I request the resource person, Dr. Farah Diba, Associate Professor, Author, and Consultant, Bangalore, to deliver her lecture on trademarks and industrial designs. Over to you, ma'am.
Thank you. And I'll just share my screen. Okay, is it visible now and am I audible clearly?
Yes, madam, it is visible and you are audible. Yes.
All right. So from yesterday's inputs and discussions, we are very much, in the mood to go ahead and take it to the next level. And please feel free to put your questions in the chat and we'll be happy to answer. And when the audience is interactive, it's very interesting and it's kind of a bonus for us. So thank you for being an interactive audience and for receiving everything with a pinch of salt. And there may be some things which may not be clear. Feel free to ask those questions. So now for today's presentation, I'm very happy to deal with trademarks and industrial designs. The reason is this is integral to any product development and marketing strategy for a commercial organization. And the reason we want to emphasize on trademarks and industrial designs is because these intellectual properties are easier to file and maintain. And when we come to the actual serious business of IP, which is patent, it is very difficult to get, very difficult to maintain and to create something new. It takes a lot of resources, but this is very simple. Even your college logo can be trademarked. Even anybody can create something which is an industrial design and easily get an IP. So in a business environment, as we had been discussing at VTPC, that if we inculcate into the audience that the trademarks and industrial designs are easier to maintain, easier to get, and then it's a very creative process. So if we know about these things, it will be helpful. So now let me take you through the trademarks, which is a very interesting intellectual property, and same as with industrial design. So what happens is when we talk about intellectual property, it should be for the purpose of economic activity because the whole world is driven by economics. So once you know what is an IP and you know how to safeguard it, not only the technology, but brands also. So the brands are cultivated over years and we create a lot of goodwill and a system which includes your consumers and the technology producers who work on that. And yesterday also we mentioned the freedom to operate, to know what not to do, what to do depends on our knowledge of this whole spectrum of things. So if you have the freedom to operate, you can go ahead and invest your money in that. If not, then you will have another strategy. For example, taking a license. So there are ways to do something in a legal manner. That's what we have been driving from yesterday. So this is what we discussed yesterday. And today, out of the industrial rights, we'll take patent has been dealt yesterday by Rama sir. And we'll take up trademark and industrial design, and then we'll go ahead with the other things. And if you have doubts, you can tell us what is the next session that we can tailor for you. All right. So as we mentioned yesterday, these are all the tools, and you can choose a combination of tool that suits you best. So this Panama hat is a very iconic thing from Ecuador, and it's a trademark. And similarly, the plate that you see, it may be a GI or a trademark or even a certification mark because it comes from a community. So these things can be, or again, the tweed from Scotland is a certification mark. It says that it's 100% pure wool. So the consumer is also happy, and the business owner creates something good, and it goes to a good consumer who can respect that work which has come from a traditional knowledge of people. So create a product and create a system around it with IP to protect it. So as we mentioned, it needs design thinking. You should know what your customer wants, empathize, define what he needs, ideate, create a prototype, test it, test market it, and take it to the market. So that's the whole idea of having these conversations. So yesterday I gave an example. Here is another good example about product development. You need creativity. There should be a utility for the thing that you have created, and it should be ergonomically designed. Why? Because nowadays we want more customer-friendly things. So this is a very simple technology. So whenever you put a tomato ketchup in a glass bottle, there's always something left at the bottom, and people have to struggle with that. So you do not have to do that any longer, because this person called Paul Brown, he created a valve which allows you to store it upside down and will not leak. So he perfected this invention in 112 iterations. See, it takes a lot of work for creating something small, but once it is standardized, then you can go ahead and patent it. And if you do not want to commercialize, you can license it. So he licensed it to so many companies, and he's a millionaire. Okay. So this is a simple problem and a simple solution. So from brand-centric marketing to customer-centric marketing is what is a design thinking framework. Now, why do we need it? Because we spend so much of our time in front of a screen and using these mouse. So we have created an ergonomic mouse now. So these avoid repetitive stress injury that you may have in your carpal tunnel syndrome in your wrist and all that. So the handles and the scissors, these are all new design, which help create a system which will be more friendly to the human body. So there's a lot of thought that is going into it. So whenever you have a brand, the way the consumer will interact with it is through the outward appearance. So the art or process of designing manufactured products is industrial design, and the ornamental or aesthetic aspect of a product is the design that you see firsthand when you hold a bottle of water or a phone. So the technology, the brand, and the way the technology is presented to consumer is the design. So it's a first impression. So if you create a good first impression, your consumer is already interested in it. Now, designs will reinforce your brand, and you can understand that the brand has a huge power over the whole business. So when you implement IP strategies within a business framework, you need to invest in things that increase your visibility, recognition, and it is important to manage that. Because when you go to the market, there are several competitors, and you want to create an impression that is clearly yours. And these pictorial designs or patterns can be protected, and mostly it is ornamental, because general shape and structure, if you see this first pot, any teapot will have a hollow body, a spout, a lid, and so on, and a handle. So there are variations of it. The third one is the one which you see in Disney Beauty and the Beast. So the child will be interested, or a youngster will be interested in that, and they will say, oh, this is a Disney product. So anything simple like a teapot also can be created in such a way that you can charge a premium over it. So the general shape and structure is not eligible, because that is utilitarian. That will be there in all the teapots. But how you create a distinguishing part. So you can see that how you can create something which is specific to a particular feeling or a psychology of a consumer who will prefer it because they have a connection with a Disney movie. So this is an industrial design and eligible for design protection. Similarly, the BMW, the front grille is split. So have you seen any other car with a front grille split? It can't be, because they have, it's a design patent. And in India, it will be called an industrial design. So that is a specific thing which belongs only to BMW. Similarly, Toblerone chocolate, wonderful chocolate from Switzerland. And you know the hills, Switzerland is a hilly area. So Toblerone, each of those triangles represent their hilly terrain and the milk that comes from that. So it's a specific thing, and we all love Toblerone. So this is a way of branding, marketing, and creating patterns and 3D marks and shapes that people can relate to, your consumer can relate to. Similarly, with a bottle of distillery, you know when they have changed the packaging, when they have changed the color from blue to aqua, and so on and so forth. So it's very, very clearly marked in a psychology of a consumer. So these are design which can be registered design, or in some countries it will be design patent because IPRs are territorial. Again, it deals with the aesthetic aspect of an article, the shape, the configuration, the 2D or 3D features, lines and colors, ornamentations, etc. So any article which is produced by an industrial process, that means mass produced, will be eligible for an industrial design because it is an industrial design. It talks about things which will be produced in an industry. So you make the product attractive and appealing to the consumer. And it does not protect the technical and functional features. Technical and functional features are patentable, whereas this is an external appearance. And why it is important to protect it? Because somebody can make a copy which resembles an external appearance of a good product and make a fool of the person. So somebody, whosoever is trying to copy it, will not be able to copy because it is IP protected. So it requires a lot of creativity. And then there should be harmony between the functionality and the form. So you have a machine, the way it is packaged, the way it is presented, and how you hold it. So all that matters. So there are aesthetic considerations and there are engineering aspects. And that will define the material that goes into it. What will be the production process? What will be the strategy of pushing it into the market? And it requires a lot of strategic thinking and decision making, because the industrial engineers, the designers, and the business experts will all sit on a table and decide what goes into a particular production. So the design thinking organizations will integrate design fully into their product development process. So it's a process in which everybody is involved. So they will protect the distinctive appearance and get a design registration so that nobody else can fool the customer by imitating it. So you can have packages, containers, furnishing, household goods, jewelry, airline interiors, automobile interiors, automobiles, anything can be protected by industrial designs. And it can be an ornamentation on product package or trade dress, all those things, a hologram, a cartoon character, animated icon, all those things can be under industrial design. And electronic desktop icons also will be considered. The fonts will be considered as industrial design. Then again, graphic display on monitors of the computers. And of course, mobile phones, you know, there is a huge variety, and you know, this is a Samsung and this is an Apple and this is so and so because of the external shape. And people prefer those because this one is easier for me to hold, and so on and so forth. So there is a history of it. So we discussed about Coke yesterday. Again, you see how they have created the industrial design over the years, and it has evolved. It's an industrial design and it's their trademark. You can see that the red and white font and how it is packaged is very, very important, because the customer is going to hold it in their hands and they should feel that they are having a genuine product. So that's the psychology. So now taking again issues, what could be issues? So this is an example. So our fresher student designed this bottle, which is called an Eco Coke bottle, which is a Tetra Pak, I suppose. And it will have paper and cardboard, plastic on that. So he designed it to say that we will not use PET bottles. But what happens is that when you think practically, 12 flowable ounce will be there in that, and it is carbonated. So there should be a bottle which can hold that volume as well as the carbonation activity. So if you take a square bottle, eventually you will end up with the same amount of plastic that the PET bottle has, because it cannot handle the stress of carbonation. So there are practical considerations with design as well. So it's very important to have the design, the actual product, and the considerations that go with that. So this kind of a design looks nice on a paper, but it will never go into production because of practical considerations. So please understand that the functionality and design has to go together. And again, as I mentioned yesterday, do not publish before filing. Here also, do not disclose before registering your design, because there is a system where you can go and register. And it should have novelty, originality, and individual character. And it should be significantly different from known designs or combinations of those. So yesterday I was showing you databases where if you type that, you will see the trademark. Can we have some silence? There is some disturbance here. Okay. So, and it is renewable. So registration is important because you want to invest in a design. There's a huge thinking process. You'll get design consultants. So you need return on investments. If you do not protect it, you will not get return on investments. And the exclusive right is for at least 10 years. Then you can renew it. So the packaging, you see how beautifully they have packed. It's a Kleenex, but how beautifully it is packed. It says a message which says refreshing. So it must be wet tissue. But the packaging itself is so attractive and suggestive. So the customer will go for it. So you will be able to strengthen your brand by using a good packaging. So if you have done that, you can even license or sell it to other people. It creates a positive image and easy to defend. If somebody is trying to infringe upon your right, you'll be able to defend because you have a registered design. So people, when they imitate a well-known product, they harm the reputation of that company. So we do not want that to happen, and we do not want to lose our revenue. So there should be a two-pronged approach. First is to be knowing what's going on in your area of work, and then who's messing up with your work. If somebody is doing that, you can take them to court. These are new ideas: a charging stand, an electronic luggage tag, a watch for the blind. So all these things are prototypes which can be commercialized. So first is to create a prototype, see the functionality, patent all those functional elements, create an industrial design, then register the design, and then take it to the market. So first protect with an IP, create a fortress of IP around your product, and then go to the market. That's the idea. Again, this is a carbon fiber bathtub. So simple items that we see in our daily lives, but they have such beautiful designs and they're so attractive that we wish to possess them. So this is how you can be creative. With the same material, if you have a good design, you can create something which is out of the world. Again, how the messaging happens, the trademark, the trade dress, the industrial design, all of them come together. And they create a whole package of things that people will be able to understand. This comes from a company called John Deere. And if you see the combination, the yellow and green combination, it's iconic. If somebody wants to copy that, they will take them to court. So go to the WIPO Global Design Database, search by design and source. And what you will get is this. See, if you search for aquaponics, you'll get these kind of drawings. Greenhouse, you can see these kind of drawings. So you know that these are already existing. So avoid that and create something different from that. So awareness is very, very important in this high-tech field. Again, if you see a citrus juicer, it's a common item, but people have created different prototypes for that. A headphone, a cell phone, or a cell phone camera. So these are the things that you encounter every day. So if you know that these things exist in the database, you will create something which is distinct from this, because that will be your design. So that's the idea. And the information is out there. We need awareness. And you can see the URL there, https wipo.int. You can go and see that. Similarly, once you have a design, you have a product, what will you do? You'll put it in the market. And when you as a consumer go to the market, you go for shopping, how do you create a decision? You have to come to a decision, which brands are you going to buy? So the brand is an article with a stamp on it. So when you buy anything, you will consider certain factors. What is the reputation of that product? Is the design attractive? Is the packaging attractive? Is it the one that you bought last time and you were happy with it? So you have a goodwill about it. You have a good experience about it. So marketing strategies have to include brand and design, because they need to attract and they need to interact with the consumer at that level. And these are all IPs. You can legally protect it. And there's a very subtle undercurrent to it, which is about understanding social, commercial, and aesthetic attitudes of say, a particular geography. People consider some things, they have their own social norms. We have to respect that. So multinational companies will come to a different geography. And in Indian subcontinent, they have one advertising strategy. In Europe, they have another advertising strategy because the consumers differ, their cultural backgrounds differ, their preferences differ. So this is what drives it, the brand, which is a trademark. It's an intellectual property which creates value and identity. So it's very important to inculcate a brand, to nurture it over the years. And we should be aware that this is an IP and create our own IP. So it's a sign or a visual symbol that individualizes your goods or services. So it's applicable to goods and services of a given enterprise. So you will be able to say that this particular is an iPhone and this one is a Samsung phone. So you know that from the shape of it, from the trademark on it, or it may be a service mark like an airline company. It may be a trade name, a trade dress, a domain name. We'll discuss all this as we go ahead. So there are different classes under which we'll classify these. So some of the classes will cover goods like computers, bottles, and others are services like insurance, airlines, IT services, catering. So there are different trademark classes, and under that they will be classified, they will be given brand names, and they will have logos. So we are all familiar with Microsoft and McDonald's and Nike and KFC. These are iconic brands, and we know them. So brand has a power because people prefer certain brands. So some people are Sony loyalists, some people are Panasonic loyalists, so some people are Apple people. So people have a preference and they have a brand loyalty. They always, when they want to replace the product, they will go for a same brand. So that is called brand equity because it has a power over the consumer. The consumer had a good experience, good after sales service, and all that will come to ultimately choosing a particular brand. So there'll be logos and there'll be taglines. So it may be a concocted one like Kodak. It's an arbitrary word, or it may be suggestive like Swatch is a Swiss watch, Airbus, Nescafe. So people will be creative. You have to be creative in this field. So again, cultural symbols, colors, they have meanings, and our psychology is such that we will relate to it. So technical requirements, because it has to be printed on a product. And then there are legal requirements that have to be met. So it's an intangible asset. And the moment you see your brand, your toothpaste is Colgate, or you go to buy a Siemens machine, or Bosch, or Volkswagen. So you have a brand value and loyalty. And customer discretion is very, very important. You have your choice. So we all talk about freedoms and choices. So you have the choice to choose. There are hundreds of advertisements, but we choose the one which we had a good experience with. So that's called customer discretion and freedom of choice. So it's a highly commercial aspect of a product, and the customer's association with the trademark is very important. We have to inculcate, we have to nurture it, and again, how the public perceives it. So you know that there was a case where we said fair and lovely, and ultimately this generation said, why you don't think the dusky is lovely and beautiful? So they had to change fair and lovely to some other thing. So it's all about how we create value and how the customer perceives it. Kindly mute yourselves. Okay. So what are the legal requirements? So to register a trademark, it should be graphically represented in a paper form. So you see the simple black and white graphic, and you know it is Honda. So it should be distinguishing from other available trademarks or Adidas. So it's a simple graphic, but you know that this belongs to this company, and it should be able to be printed on it. If it's a shoe or a t-shirt, it should be able to be printed on that. So it can be words, devices, symbols, etc. So we'll see the examples. So the more it is fanciful, arbitrary, or suggestive, the more distinct it will be. So the more it is generic, it will be difficult to protect. So somebody was asking a question yesterday why agricultural methods cannot be patentable, because they are too generic. But when we go to the specifics of it, then only we create tests which are legally possible to apply on a object and a service to make it a clear IP which is distinguishable. So anything which is generic cannot be IP, because for intellectual property you need to have a distinct identity. So please keep it in your mind when you create any trademark. So let's see AT&T Bell. So from 1889, where there was a bell, to now AT&T in this era, how it has evolved. And there's a history behind all these institutions that have been developed. Similarly, you all know Audi cars. So originally there were 4 companies who were merged and restructured over the years. So it said 4 circles and said Auto Union. And then it has evolved, and now you see those 4 circles, only those 4 circles in front of an Audi car. So there is a history behind it. And all these brands from Unilever, which is a multinational company, we know that in different geographies, they have different businesses and how they present their billion-dollar brands. So we have the soaps and the ice creams and the tea and the soups and so on and so forth. In cosmetics. So these are all iconic brands. The Surf Excel, so on and so forth. So these are the items, these are the brands which are present in our houses, in our offices, and they are with us all the time. You can have a family name like Tata Motors, Godrej, or you have co-branding like Maruti with Suzuki. So it becomes Maruti Suzuki. So these are all branding. A signature in Louis Philippe, or a letter BMW, or a numeral 555, and so on. These are well-known brands and examples. A symbol, the tri-star symbol of Mercedes is iconic, and it may be a device. For example, the Amul Girl or the Pillsbury Doughboy. So these are wonderful examples that we encounter every day. It may be a fanciful thing, it may be arbitrary, like Shell is for fuel, Apple is for computers. And if somebody has started thinking about these things, how arbitrary marks become, but it's a branding strategy. They will create something which is unrelated, but then it will stick to the customer's mind. Or it may be suggestive, Rapid Shave, which is a shaving cream, of course, which rapidly you can shave with. Wool Light, which is wool cleaner. And these are creative ways of doing something. These are the well-known brands, Pepsi and Bata and Raymond's, which may be a surname or a name or a word. The trade dress we talked about yesterday about Maggie or Cadbury's, the typical color combination, which others cannot copy, Domino's and so on. So when we talk about trade name, McDonald's is a trade name. So the McDonald's Corp is the trade name, and the restaurants are the service mark, McDonald's restaurants. And you see the double arches, golden arches. The tagline is, I'm loving it. So the moment the children see this, they will say, I'm loving it. So it's a cultural icon, synonymous with capitalism, with globalization, and widespread proliferation of American culture. So this is how a branding exercise should be done. So again, external appearance, and you can have the, you will see the designs which are created into diagrams, which have to be submitted to the patent office. So the visual appearance will come under the trade dress. It protects all the elements, and you can see the shape and you will know what product it is. So I was mentioning about the Cadbury's. This is the typical shade of Pantone 2865C, which they use. If somebody else uses the same purple, they will sue them. And these catchy taglines, sense and simplicity, because you're worth it, for L'Oreal, and let's go places for Ford. So these are the catchy taglines that you immediately will recall as a customer. And even our DIPP has a cell for IPR promotion. They also have created their icons and their logos and their tagline, Creative India, Innovative India, because they want to communicate with us. And the GI tag, which is Atulya Bharat Ki Amulya Nidhi. So invaluable treasures of incredible India. And that tag will be there and the mark will be there, and the consumer knows that this is an authentic GI product. So it's very important for communication, how we present something, how we mark something, and how we recognize that mark. And the consumer uses his discretion. Some people want to eat organics. Some people want to include nutraceuticals in their diet. It's again a freedom of choice and a freedom of using your choice. And you have so many things available, but you go for the organics, or you choose something which you think is healthy for you or which suits you. So this is how we create a communication with the customer and present something to the customer which the person will easily and happily own. So now we talked about infringement. So here I have 3 brands in front of you, 3 packagings. So the first one is Kellogg's. So let's say Kellogg's is the original, and which one is the imitation, we'll decide. So the center one has a brown bowl. The first one, which is the original, and the last one has white bowls. Okay. The second thing is the honeycomb. The first one has a honeycomb and the last one has a honeycomb design. But Nature's Path has another design. They're not trying to imitate. There is a bottle of honey, but it's not trying to imitate that. So if you see that on Kellogg's, there is a honey pourer. So they're pouring the honey with a honey pourer. So in the last one also, you will see the same thing. So now who's trying to fool? So the center one is not trying to fool the customer. It's just saying this is Nature's Path, clearly defined. It says honey cornflakes. The first one is the original, which has been copied by the last one, which is Shanti's cornflakes. And it's trying to imitate the white bowl, the honey bottle, the honey pourer, and the honeycomb design. So now you know that somebody's trying to fool the customer. So this is a case of trademark infringement and passing off. So Kellogg's will take the Shanti's person to court. So this is another example of Heinz and the copied version, Ferrero Rocher and the copied version. So you can put your money in the wrong place and you can regret it later because the product was not good enough. So these are things which have high commercial value. So the brand valuation is usually done by the sum of all the costs incurred to build a brand since its creation. The market value, which is the market price, the current share price, and the income, future net income. Because if I show you this icon, I'm sure the gentleman will say it's a Johnny Walker, and they know what it is. So that's a brand valuation. So these are the top 10 most valuable brands which we know today. The Disney, Amazon, Samsung, Toyota, Coca-Cola, Microsoft, so on and so forth. And the top of them all is Apple. It has high reputation, quality, stylish design, and a brilliant marketing program. From the store front, the facade of the store, to the iconic staircase inside, to the whole branding exercise, it's an example which has to be taken by any commercial organization. So you see the glass cube. It's iconic and it is protected by a design patent in US. So you know that the moment you encounter something like this and that apple with a bite on it, you know what it is and you can easily spend your money on it. And people pay lakhs for a particular phone or a device. So as I was mentioning yesterday, there's a small cafe, apple kind, apple child. So you can see the apple with a child inside and a small leaf there. So this is a small cafe in Germany which received a cease and desist letter because the logo was supposed to be confusing the customers. That's what Apple perceived that. So Apple is relentless. So it creates an IP, it sustains it, and anybody tries to mess with it, they will take them to court. So this is how you create a brand, you nurture a brand, and you defend a brand. Now, this movie people would have seen. So this had a name called Simba. Now, Simba was a name available, but when they checked, this trademark belongs to Sona Beverages. So there's a beverage named Simba. So what they did, they went to the Sona Beverages company and they took a trademark license. So they did a right thing, which is legally correct. You can use it, but with permission. So they gave a license fees and they asked them to give them, and then they launched their movie. So if they don't do this due diligence, they will end up in legal trouble because the trademark is already registered by Sona Beverages. So if you know what is somebody's trademark, how you can use it still by taking a license from them, that's the right way of going about it. So when you hear the Airtel ringtone, you know, Nokia ringtone, so these are sound marks. You can have a sound mark as a trademark. And the movie goes MGM, the lion will roar, and you know that this is MGM movie. Even there are scent marks. And we have domain names. We'll discuss domain names. So there's a company called Armani, and there's a person called AR Money. So this guy is an artist. So he created a website which says armoney.com, but it became armoney.com in fact. At that point, Armani has not created a website. So when they wanted to go and create a website, they see that this is existing. So they said, this is a case of cyber squatting. They went to the WIPO panel. So when they went through the nitty-gritty of the case, they understood that the person was not cheating. It just incidentally happened that his name was AR Money and he created a website. So the whole story was that people know Armani is an iconic fashion brand, but it incidentally happened that somebody else has taken that domain name before them. So they offered to pay him some money, which he said, you can pay a little more because I have invested in this and I need to change. So they refused. They went to the court. So the court said he did not act in bad faith and he's responding to all the legal things. So he's not at fault. So a lot of such cases have come where people have made a fortune by registering the domain names of companies or famous people and offering to sell them back. So then the internet corporation or assigned names and numbers were created, and they have created a policy. Can we have mute?
2 days on the way.
Kindly mute, Shilpa. Kindly mute. Okay. So we have uniform name resolution policies now. UDRP rules are there, and there's a database portal which you can go and check if the name is available. So this is the new age problem, the internet domain names, and we should be very, very cautious about it. So India has a Trademark Act, and it is in conjunction with the same WIPO Madrid policy, the international trademark system, and we are in line with that. And there's a Madrid protocol according to the WIPO. We can follow that. You can register so that nobody has a free ride over your trademark. It will go through the process and you will get a registration if it's all clear. And then you will renew it every 10 years. And you'll get a certificate like this. So can somebody say, what is this? Anybody? What machine is this? Yeah.
Xerox machine, ma'am.
Copier.
Okay, good, very interesting. All right. So it's a Xerox machine, somebody said? Okay. Basically, Xerox is a trademark. And it is a photocopy machine, but we say Xerox because it's a generic term. Okay, please understand. Anything which is generic will not be able to get an IP properly. But this was a trademark which was used and overused and became a generic thing. Okay. So they had to, actually over the years, they changed their logo also to make it look fresh. This very often happens. For example, you go ask for Surf. Actually, it's a clothes washing detergent. So people say Surf Dera. Okay. So this has also become generic. So somebody will say, get me aspirin. Aspirin is a trademark of Bayer, but it has become generic. So the loss of distinctness in a trademark becomes a generic term, and it often happens because of overuse. Then they have to rebrand. So these are other examples of bubble wrap and Kleenex and escalator and all that, chapstick. These have become generic trademarks. So they have to rebrand their product because it is overused, and people have become used to calling something like that. So this is the Trademark Search India. You can go to the website and search, and you will know what is there. Or you can go to the WIPO brand database. And if you type Maggie, you will get this red and yellow graphic, which says that Maggie is protected under this image. So you should create something which is different from this image. Then only you will get a trademark. So if you type car rentals, you'll get these kind of logos there. These are the top industries, and you can see agriculture, the highest number of trademarks filed are by China. And you can see transportation, where Iran is there. And then you can see research and technology, Germany, Japan, US. They are the highest trademark filing companies and countries. Then clothing and accessory, China. So you know that where the branding activity is happening, which country, which geography is more inclined towards research and technology. So you can see that. So this is the graphic from WIPO, and similar other facts are there, and you can be aware of that. Thank you so much for your patient listening. And if any questions are there, I'll be happy to answer.
Thank you, ma'am. If anyone has any queries, they can directly ask us in chat.
Gautam, I think there is one question in chat box.
Yes, sir.
There's one. The question is whether there can be sound and smell
marks in India. Sound mark, definitely you can see Airtel is there, and it is quite iconic. And A.R. Rahman has given that tune, so which we all recognize very well. So smell marks, I don't have examples right now, but in international market, there are examples of strawberry flavored toothbrushes and all. And then there is a store called Verizon, which has a specific smell, so that they have taken, but I don't have examples from India. Okay. Any other questions?
Yes, ma'am. I have one question.
Okay.
If any well-known company has changed its trademark, then can any new company use a similar trademark which is already changed by a well-known company?
So the whole idea of this. Okay. So the whole idea of this exercise is to make you aware that people would have registered, and if they have registered their trademark, you can go to the different websites. You can go to the Indian patent website. You can enter patent and trademark website and search. You can go to the WIPO. You can go to European Union. You can go to USPTO and check if something like that is there. And it's a huge exercise. People have had a trademark, then they change it. They call it evolution. They can evolve it when their things change. For example, I was working with Monsanto. So when I joined Monsanto, their logo was an M, which was red. So later on, the team, the logo designing team discussed, and they said red is negative, so let's change it to an earthy color. So they changed it to the soil color in green, which people will recognize as a life science company. So it's a life where there is soil and there is greenery. So a lot of thought goes into it. But if somebody imitates that, there'll be trademark dilution and people can be taken to court. So yesterday I had shown that Coca-Cola, similarly, some other company created Chica Loca and something else. So they will immediately, one is you create a trademark, you create an IP, and you be vigilant. If somebody is messing with it, you'll immediately take action. So if somebody is doing it, one is they're wasting their time, energy, and money, and they will be taken to court. Again, they will be in legal trouble. So before designing, one is to be aware, see what is out there, and then design something which is different from it. Okay.
Okay, ma'am. Thank you.
All right. If there are no other questions, we can go ahead.
Morning, ma'am. I have a question.
Yeah, please go ahead.
Ma'am, if a company has been using a brand for 2-3 years and then later they decide to get it trademark, so can they do it?
Yeah, it has happened in the past when all these things were not very well known, and the commercial activity was not so much as it is today. At that time, some people had simple trademarks, and they used to use it in a local way. But when they wanted to expand their business, at that time they had to register. So there are something like a Ganesh BD or something, they never had one. But everybody knows that this is particular thing associated with this company. So people would avoid on an Ayurvedic product like the KP Nambudiri. Okay. So there was a company which came and said KPN. So they again objected to it and they had to change. So there will be existing trademarks which are not registered but well known. So if you go to court, they will put it through a test and then they'll say, okay, for this long it was existing, this much was the public perception. So even if they are not registered, they had a reputation. So they will be in the favor of a person who has come later on and trying to imitate. So the court will take it, case by case. So what we have to do is register, because now the economic activity is a lot and we can even go to a global level or to a regional level, and it's good to register whatever IP you have. All right. So
Ma'am,
there's another
I have a question.
Yeah, please go ahead.
It was a wonderful session, ma'am. Thank you so much. And I would like to ask one question. Since the market is like very competitive and it's like every now and then there is new product development and companies are investing into huge R&D and new products. And is it a challenge to, if the IPR rules and processes or the regulations are weakly implemented, or there's no control over the implementation of the rules, is it going to impact the new product development?
So what has happened is that now we are having these sessions. Okay, 10 years back there was no awareness. Then the WTO TRIPS, when it came and they started regularizing everything, then things are becoming regular, and we are the beneficiaries actually of this regularized process. And we can take our brands to the whole world actually, if you have protected it and registered it. If you know what is the process, you know what are the problems that you can encounter, they can overcome it. So it's very important to create rules and then follow the rules. There should be awareness. So we have these exercises of creating awareness and taking advantage of it. So yes, there are issues, but the person who creates an IP has the onus on them to defend their IP. That's how it works. So you should be creating something, defending it. Okay, that's how it works. Okay. So
Okay,
there is a question. There's a question here. What is deceptive similarity and its effects? So basically, somebody is trying to imitate somebody deliberately. So I had mentioned, I think yesterday, something is substantially similar and the person who has access to it knows it. So the person has access to it and he still created something substantially similar. So one is there will be loss of revenue for the person who originally owned that IP or owned that work. And there will be loss of revenue. If there is a lot of loss of revenue because of confusion, then you will go to the court and insist that this is my IP and you will defend it. So there will be deceptive similarity, and it happens a lot in India and in China, where mass-produced things are there and people can be fooled easily. And there will be loss of revenue. That's the answer to this question. What is deceptive similarity and its effect? So somebody is trying to deliberately imitate a well-known product. That is a deceptive similarity. And it will be a case of trademark dilution or infringement, and people can go to court and they may have to pay the damages. Okay, we can go into specific examples. I think I have answered this question. Any other question?
Excuse me, ma'am. Ma'am, I have a question here.
Yeah.
Madam, as you told just now that if a trademark is overused, it becomes generic. Okay. Then what are the effects and what the company can do if it becomes generic? Okay.
So everybody tries to have a distinct trademark, but then something like a bubble wrap. Okay. It's a pretty generic thing. So somebody branded it like bubble wrap. Over the years, people used and used and used and used. So what they have to do is they have to rebrand. Okay. Because we call it too much used and too much generic. So there was a case where there was a GI, feta cheese. Okay, so I'm taking a GI example. So that feta cheese you can find in any country over the shelf. But in fact, that feta cheese is a cheese made out of goat milk, and those goat have The courts are there on a particular island in Greece. So now you see how they defended. They went to the court and they said, this is our IP, this is our traditional knowledge. We will not allow other people to use it as a feta cheese. You name it something else, you brand it something else, but leave this feta cheese to us. This is our traditional knowledge. So they fought back for it. So there are ways of doing, either you can rebrand or you can fight and ask the court to restrict other people's activity on that. Okay.
Okay, ma'am. Okay.
Excuse me, ma'am.
Okay, if there are no more questions, yeah.
Actually, if we are speaking about the trademark smells, then we have different kinds of huge brands like Tom Ford and all who are using the sandalwood smell. And we have local ether making companies who use the similar kind of smells. And also it might be having GI, I'm not sure, but how do we protect the smaller companies from these huge brands where it is similar, but how do you protect the smaller companies?
Okay, now, so let's understand one thing. The sandalwood thing has become very generic. I think everybody understands that. So even for anything which is traditionally used, something which is very generic will not get a IP, either a GI or anything else. So it's very difficult to prove in a court of law. This is specific. So we have to use other strategies. Okay. So when we talk about smell marks, those are huge companies. There's a company called Verizon. So you can check that out, that case study. So they will have a specific smell for their store. So now you see it's not generic. It's a specific place with a brand and an additional brand on top of it, which is a smell mark. Okay. So when something is generic, it cannot be IP because it's common knowledge. So you have to create something which is distinct. So if I say Kodak is not occurring earlier. It's a made up name, but you know that it's a camera brand. So again, the whole idea is creating an identity, creating a specific identity. So that's the whole idea of IP. And if you create a specific identity and you are able to get an IP, which goes through the whole gamut of processes and then legal tests, and then they'll say, okay, we'll give you this. Okay. So that's how it is. Anything generic. So again, that's agricultural methods like pest control. You can kill it with a pesticide. You can have a specific pesticide which you can trademark. You can have a patent over the process of creating that pesticide. But if it's something like squatting a fly, you cannot have any IP over that because it's so generic. So I think we are over time and we can stop here. So thank you very much. We'll come back to it. Okay. Thank you.
Thank you, ma'am.
Thank you, madam. It was a very great session to listen to you on trademarks.
Thank you, sir.
Yes, Gautam, please go ahead.
Thank you, ma'am. It was very informative. Now, I request the resource person, Dr. Ramamurthy, Senior Advisor, Origin IP Solutions, Bengaluru, to deliver his lecture on career opportunities in intellectual property rights. Over to you, sir.
Okay. Am I audible now?
Yes, sir. Good morning.
Good morning. Am I audible?
Yes, yes, you are audible.
Okay.
Perfect.
Okay. Good morning to all of you. And you had a wonderful session earlier, and it was very interesting. Thanks to Dr. B.V.Bellad for giving the beautiful presentation of trademark and designs. Now, my presentation is on the career opportunities of IPRs. Now, as all of you have learned from that earlier sessions, IPR has got several tools like patent, copyright, trademark, and each one of them has got a career opportunity, not only for engineers, but also for advocates. So each one of them can be considered as a very potential place where one can get a job. Now, intellectual property refers to creations of mind. We already know this. To protect these creations, the law comprises provisions in the form of different tools like patents, trademark, etc. And now,
Ramamurthy sir,
yes, yes,
sorry to interrupt you.
yeah.
Sir, please make the slideshow. Sir.
Okay, okay, I will do that. I will do
I
that.
think you forgot. Okay.
Okay, that's fine. Okay.
Okay, sir. Okay, sir.
Okay. Now, since the present seminar is for advocates, so I will say what is the career in intellectual property rights for advocates. See, IP refers to creations of mind. Protect this, we already learned these things. Now, these rights are collectively are known as IPR, and this we already know. Now, what are patent laws? Patent law is a domain of IPR law that requires practicing professionals to have a sound technical and theoretical understanding of science, because patents primarily relate to core technologies, inventions, and related work. So the IPR law, of course, the people who are doing this course may have a background of science. So in addition to the law, they should have also basic knowledge of science. So that will help to get a very good career in IPR. So first of all, you should understand who can file the patent application. Even here also there is an opportunity for career. In order to file a patent application on behalf of the client in India, it is very important for a person to be a registered Indian patent agent. Now, a registered patent agent means he is a person who firstly at least a graduate in science. A graduate in science is a must, and has secondly cleared the Indian patent agent examination, and lastly has registered themselves as a registered patent agent. So this is one area where people can take up this patent agent exam and they can become the patent agents. So they should have this examination passed, and also they have to register for a patent agent. Due to this, a patent agent who may not be an advocate becomes authorized to draft, file, prosecute patent applications on behalf of the clients. A person who is registered as an advocate with bar council, okay, but not as a patent agent, is not authorized by the patent office to act or on behalf of any client and to draft, file, prosecute their patent application in India. So patent agent examination is a must. But when will the advocate come into picture? See, when there is a patent litigation or infringement, the advocates can fight it, or they can represent the client in the court. The list of registered patent agent is published in the official website of Indian Patent Office. Now, there is always a confusion between patent agent and patent attorney. Or who is a patent agent? A patent agent must be a citizen in India, and one should have completed 21 years of age and have obtained a degree in science or engineering or technology from any university established under law for the time being enforced to the territory of India. They have passed the qualifying exam described in the purpose. The qualifying exam stated is patent agent examination, which is conducted every year by the Controller General of Patents. Passing this exam is a must in order to qualify for a registered Indian patent agent. Then the next question comes, what is the role of a patent agent? The patent agent is a qualified person who can take up patent prosecution. The role of a patent agent is described in Section 127 of Indian Patent Act 1970. He is entitled to practice before the controller, the controller of patents, and prepare all documents, transact all business, and discharge such other functions as may be prescribed in connection with any proceedings in the controller under this act. So patent agent can file the patents and he can take a further prosecution. Whereas a patent attorney is an advocate who practices IP law and may or may not be a patent agent. Now, a patent agent is qualified for patent prosecution. Then the next question is, who is the patent attorney? A patent attorney is an individual who is entitled to deal with patent litigation by virtue of holding a law degree. See, in the earlier session you learned there are a lot of infringement of trademarks, patents, or trade dress, whatever it is. And these litigations can be handled by patent attorney. A patent attorney or a patent lawyer is an advocate. This means that an individual who has a law degree and has enrolled in the state bar council is an advocate who can deal with patent litigation and is hence a patent attorney. It is important to note that here that a patent attorney does not necessarily possess a degree in science, technology, or engineering. Whereas for a patent agent, degree in science is a must. Then, what is the role of a patent attorney? Mainly, the role of a patent attorney is the same as the role of an advocate. Thus, a patent attorney can specifically deal with patent litigation. This means that a patent attorney represents patent cases in the courts. I will mention some of the court cases at the end of my presentations. That's quite interesting. And it is important to note that a patent attorney cannot file a patent. This means patent attorney is not entitled to do the patent prosecution, that is patent filing and further process, and only the litigation aspect of the patent can be handled by him. So to put it in the form of a table, I would clearly mentioned here what is a patent agent and a patent attorney. So as we already discussed, it's a summary of things which we have discussed so far. Patent agent has got a degree in science or technology or engineering. Patent attorney may have a degree in science, technology, engineering, but not necessarily. Degree in law is not required for a patent agent. But for patent attorney, you must have a degree in law and must pass the patent agent examination. But in the case of attorney, they must have enrolled in the state of bar council. And patent agents prosecute the patent, they take up patent prosecution, and patent attorney takes up patent litigations. And patent agent practices before the Controller General of Patents and Designs, whereas patent attorney practices before the court. So this is a very clear distinction between patent attorney and patent agent. Now, to further to go, you see, after completing the degree in the law, if you want to take up IPR as a profession or a career, there are a lot of courses on IPR, which I would suggest people can take it up. So that will help them in their career as a patent attorney. See, there is a course from World Intellectual Property Rights. These are some of them are free courses. You can register here, and you have 2 months course, 3 months course, and you can get a guide from anywhere in the world, and that one can take it up that. Secondly, the Udemy IPR certificate course, FICI. National Law School of India, University Bangalore has got a PG diploma on IPR, and that's a very good course. It's a 1-year course, and you can attend the classes on Sundays. And similarly, NILSER in Hyderabad, they have got a PG diploma in IPR. Indira Gandhi National Open University in New Delhi has got a PG diploma in IPR. This is for people who have already completed engineering or science, and they can take up this course. Hyderabad University will get a diploma in IPR and Swayam online courses on IPR. There are so many online courses after this COVID has come. And similarly, there are other master courses in IPR and certificate course in IP law and prosecution, and law sequel diploma in IP, media, and entertainment. Can you please mute, please?
Yes, sir.
Okay. Now can I continue? Okay.
Yes, sir. Continue.
There are top colleges and institutes for intellectual property right courses. There are plenty of them, and one can choose depending upon their choice. Amity School in New Delhi, Rajiv Gandhi School of Intellectual Property, IIT Kharagpur. See, I think in IIT Kharagpur there is a 2 year course for engineers. One can take up a 2 year course on IP, and of course, the job is guaranteed because it is a high-level course. And Nalsar University in Hyderabad, GNA Patent Gurukul Mumbai, and there are so many institutes in India. And Srishti, another society of research initiatives, Indira Gandhi National Open University, Hyderabad, National Law School, so many things, so many places are there, and one can choose the place where they want to continue their studies in IPR. Now, the next question is, what is the role of IP professionals in the legal domain? See, here there are a lot of opportunities for advocates who have completed their law degree, depending upon the type of work. See, for example, the first one is drafting and filing a patent specification. This is the most important portion in a patent document, because when once an invention is made, when once the disclosure is made, a patent is filed in the patent office after drafting. Drafting means it is not like writing a paper. It should be written clearly, and it's a special efforts and special skills are required to write this, and that you can get training in the courses which I already told you. So patent specifications are one of the most complex technological documents. It is not only giving the explanation of technical or scientific explanation of the invention, but also you should give the legal aspects to that. And one needs to be highly proficient in English and possess scientific knowledge and understanding in order to draft the patent specifications. Once a patent specification is drafted, it is required to be filed online. Nowadays, it is done online along with various forms and the required fees. And one needs to have a thorough understanding of the Patents Act 1970 to understand the right forms and fees. This Patent Act 1970 is available in all bookshops, and you can buy that and you can go through that. It describes how the patent has to be filed and what is a patent and all those things. Now, in order to file a patent application in India, one needs to register, as we already discussed. It should be filed by a patent agent. The second portion is patent prosecution. So after the patent agent has filed in the patent application, patent prosecution means in the patent office there are a lot of examiners in each domain, like engineering, science, biotech, and agriculture, all those things. So your application will go to the particular area in which it has been applied. So an examination report is issued by the examiner after the examination of the patent application. And invariably, there will be objections. So understanding the objections of the examiner requires a lot of experience and knowledge of both subject of patent application and also the process followed in the patent office. And preparing a reply or response is also a very specialized skill, and learning this skill adds to your capability. Value to the profile of the candidates aspiring for a career in IP. That is one area where one can specialize this. And next is, what is prior art? This is one area that's also a lot of opportunities for science graduates and advocates. See here, prior art such means, as I told, as Dr. Faradiba also told, the three conditions to get a patent are the one is novelty, another is usefulness, and another is non-obviousness or inventive step. But now, more particularly, what happens is prior art comes into picture because in order to prove novelty of an invention, you should make sure that nobody else has done it. How do you make sure that nobody else done it? That is known as prior art search. So it may be patent documents, it may be a publication, it may be a newsletter, or it may be any other information available in the public domain. So before you file the patent application, you should do this prior art search to make sure that nobody has done it. So prior art refers to any such technology that would invalidate a patent or limit the scope. See, if you don't do this search and file a patent, what happens is the examiner will find out through patent search, because he has the access to all databases in the world. When once it is shown by the examiner that your invention is already there, you can't get a patent. The process of prosecuting a patent or interpreting the claims largely consists of identifying the relevant prior art and distinguishing the claimed invention from the prior art. There is a portion in the patent specification writing that is called claims, and claims is the most important portion while drafting the patent application, and claims is the legal portion of the patent document. Now, in the claims, one should be very clear, and they fix the boundaries in which under the invention work. Now, what do you mean by prior art search? A prior art search is organized review of patent documents, journal articles, technical publications, disclosures, and other public information. A good prior art search will reveal if an invention has patent protection. It is the best way to determine whether the invention is novel, useful, and non-obvious. It can also reveal if the invention infringes the existing patent, thus possibly resulting in a legal challenge. This is where the advocates and the career opportunities are there for advocates. When once a patent is infringed by others, or if you infringe other patents, it becomes a legal case, and that is the work of a patent attorney. And this is one area where it's a hot area. This patent litigation and infringement, it's a hot area where one would like to work, because that is where the lot of opportunities are there. And particularly in US, the patent lawyers, the patent attorneys, they take up litigation because that is giving them a lot of money. Purpose we already know, to prove that it is patentable. The purpose of prior art is to access patentability of new ideas or inventions, assess the idea worth investment, prevents duplication of research. See, if you do prior art search, only first is you will be saving a lot of money and time, so that you won't file the patent and spend money, and also it prevents duplication of research. If you want to do research, better to do a prior art search, so that it will help you to go in which you have to find out in which direction your research goes. That helps in that, and helps to fine tune the idea and create better product. And even in prior art searches, there are so many types. One is patentability or novelty search, which you will do, which everybody has to do it before filing the patent. Next is freedom to operate or clearance search or right to use search. See here, suppose you want to you would like to bring a new product into the market. Without doing this freedom to operate search, you may get a legal notice from somebody somewhere in the world telling this product has got a patent from our company, you cannot do marketing. So before you bring any product to the market, you have to do this freedom to operate search or clearance search. So this is also one specialized area, and one should take the help of professionals to do this. And validity or invalidity of enforcement of readiness search. So suppose you find out that in the prior art search somebody has already done it, and that person can invalidate your patent because he has already done it. And state of art search is done before you take up a new project or a new research project. Suppose you want to do something on nanomaterials applied to viruses, like that. So you have to do state of art search. This search gives you the latest technology that is happening in vaccines or whatever the field it is, like electronics or IT. So unless you do this detailed search, you will not know what is happening in the world as on today. And next is technology landscape analysis. You take any technology, say for example, cell phone technology, you can make a technology landscape So here technology landscape gives you an idea what is the technology used and is there any further scope for improvement and all this. And this is also sometimes called as a white space technology. White space means there are certain areas in which the research has not been done and one can take up research in those directions. So it is prior searching is like a filtering, for example, understanding the invention, and you do by classification search, keyword search, assignee search, and finally short is the references, and then find out whether the invention is a new one or not. Prior search is a combination of technical intelligence, legal intelligence, and business intelligence. So if you do prior search, it will help three types of people. One is technical people, another is legal, and another is business people. I would like to say some more information on Indian patent agent examination. One can easily take up this examination. You have to put some effort, and there is no specific syllabus for this. The earlier question papers is the syllabus that is available in the Indian patent database. And there are certain organizations who will train you to take up this examination. For example, our company Origin IP also helps you to take up the patent agent examination. There are so many other organizations, they conduct courses for completing this patent agent examination. And it is once in a year. And this exam, what is there in the exam? It proves the aspirants on their knowledge of Patent Act 1970 and rules. There are patent rules also, and also assess the drafting skills and interpretation of the patent specification and other documents. So when there is a document, you should be able to interpret their meaning. And secondly, the recent graduates in stream of science, engineering, and technology who have completed 21 years of age are eligible. And interested applicants wishing to apply for this exam, I may go through this www.ipindia.nic.in. So you will get a lot of information on this, and it's still worth doing this examination. Now, coming back to PRR search, there are important 5 steps you have to follow in this PRR search. Brainstorm keywords. Usually, when all of you know, you use Google. When you use Google, you have to use the keywords. If you use the wrong keywords, you will get something else. So you have to use the before you use it, you brainstorm keywords to describe the invention. Your keywords should be as near to the invention as possible. So I'll give an example here. So I asked one of the students to make a prior search on cascades, CASCADES, cascades. Cascades means if you go to dictionary meaning, it is actually a waterfall or water falling from a height in a particular form. But in the case of aerospace technology, cascades means it is a group of turbine blades or turbine or compressor blades used for testing. So I gave it in the context of aerospace. So that student simply followed the dictionary meaning and followed. So before you start doing research on the brainstorming the keywords, better you understand the context on which you are doing it. And search the patent databases. There are so many databases. US database is there, European is there, Indian, and also patent scope. And the most important is Google Patents, which covers all the patents in the world. These are all some of the free sites which you can utilize. Expand your search beyond patent databases. In addition to that, you have to go through documents and other documents like publications and even pamphlets or company brochures, and save all relevant results and documents. And when you start searching, it will be like a big ocean. You should know when to stop. Free databases. Google Patents is the most very good one. Google Patents indexes more than 87 million patents and patent applications with full text from 17 patent offices, including USPTO, EPO, and databases from China, Japan, and Korea. So this is the best free database available in case you want to do the searching. But let me tell you, you will not get the required results in one shot. There will be a lot of iterations, and you have to make a group of keywords, combination of that, and finally you should get what you want. And another database is freepatentsonline.com. That's also a good one. And there are some commercial patent databases for which you have to pay. And most of the data here, this commercial one, it is very costly to buy. So organizations buy it on yearly basis. They have to pay some fees for that. Like title, database, dialogue from Procust, Orbit is very good one. STM, Thomson Innovation, like that. But USPTO GOV is a free one. Now, IPR law is amongst the rare breed of law practices where professionals with varied backgrounds in domains engineering, such as engineering, biotechnology, chemical engineering, pharmaceuticals, are fairly successful despite their seemingly unrelated backgrounds. So this is one area where all the people meet, business people, and technical people and law people, and in with different domains, as I said. And this is a very interesting area where one can take up the career. Now, there is one more area where advocates can get lot of opportunities in career. That is called patent or IP audits. Now, patent or IP audits at the time of acquisition and merging of companies, where there may be a need to check the legal status of the patents and docketing of the same for upcoming deadlines, renewal of fee collection, etc. That is one area where that's a very hot area. And valuation and commercialization of the patent. This is also an area, very specialized area. Here, you may get a patent granted, but you should know how to make use of it. So, if you want to bring the product into the market, people will ask, what is the value of your patent and how to commercialize it? So here, negotiations and drafting of technology transfer documents and contracts may be required to be done by an advocate at the time of such transfers. This is also a hot area where advocates can get involved. And another is paralegal services, for example, docketing of patent cases and coordination with foreign attorneys regarding foreign patents is required by most law firms, and this can be undertaken by advocates. Here, what happens is, when once you file the patent, that is not the end of the story. As I told yesterday, after the patent is granted, every month it should be renewed. And not only it should be renewed, but you should keep track of it, because you may forget. For example, if a company is having some 50, for example, IPM has got maximum number of patents, maybe running it to 800 or 900 per year or even more. How do you manage it? Unless somebody looks into when the patent is granted, when it is going to expire, that is from the date of filing, it is 20 years. And when the renewal of fees is due, so one has to keep track of it. And that is known as the docketing. And this is one area where a lot of scope is there. And not only that, even foreign patents, if they have filed, have to be monitored. Advocates may practice in the following areas. Such as freedom to operate searches can also be carried out by advocates. As I told, when you want to bring a new product into the market, you should find out whether any product is available already, not only in India but abroad. For this, specialized searches such as these are usually performed by patent agents, but advocates have a vital role to play in claim interpretation. See, when you study a patent document, there is a portion called claim, and that is a legal portion, and there you should read and understand clearly. In fact, several companies require such FTO, means freedom to operate searches, to be signed by advocates. And patent related disputes like patent infringement or litigation. This is one hot area, as I told. In US and other countries, this is a very good area where the patent attorneys make a lot of money. and portfolio management of innovative companies to look after legal commercial strategies, planning regarding portfolio creation, management and licensing of technologies, etc. See, each big company has got a separate unit of patents where there are a lot of advocates working, and they will be studying the opportunities for merging of companies and planning regarding portfolio creation and licensing of technologies. See, what do you mean by licensing of technologies? Suppose you have a technology in your company, you want to make money out of it. One is, of course, you can sell like any other property. That is, you can completely assign it to another company by taking a large amount of money. But another method of marketing is licensing of technology. Suppose you have a, for example, in National Aerospace Laboratories where I was working, there was one technology for solar heating of solar heating panels. There was a technology for the black chromium coating. See, this technology was licensed to nearly 25 to 30 companies. See, what happens when you license the technologies, you are giving permission to manufacture, but still you are the owner of the patent. You are not losing the ownership. But if you sell it, assign it to the completely to other company, you are losing the ownership. Just like your BDSI, just like leasing a house or selling the house. So the best option is to go for licensing of technologies because you will not be losing the ownership of the technologies. Trademark is one area which was discussed extensively in the last session. And here also advocates play an important role, advising clients on selection of trademark for new products and services. Trademarks such as to give an opinion strength of the mark. So advocates can give their opinion on the trademark selected. Preparing, filing and prosecuting can be taken up. Handling oppositions, disputes, litigations can be taken up by advocates. So as I said, IPR jobs is diverse work profile. So which are the domains where job opportunities are available for advocates? One is drafting. Here, understanding the inventions, strategizing the protection, articulating the inventions, understanding the nuances of language is very important. Litigation, filing and prosecution, and teaching, training, and spreading awareness. This is also one area there is a lot of scope. So there are a lot of institutions in India. They will teach about IPR, they give training, they give spreading awareness. And there is the patent office in Delhi and Nagpur. They are all conducting a lot of courses and giving training to people and thereby spreading the awareness. There is an organization called CPAM, which is taking all these training programs. Analytics and strategy. See here, the names of the names of the posts is patent analysts, patent engineers, like that, and patent associates and patent business associates. These are the type of posts you can find in Naukri.com. If you go to Naukri.com and put jobs and patent, you'll get plenty of job opportunities, particularly from companies, big companies, and also patent companies, IPR companies, and also from universities for teaching. There are a lot of scope for these jobs. And as lawyers, you should know what are the acts that are used in IPR. The fields are governed by certain stipulated acts. This is Trademark Act 1999, Patent Act 1970. It is amended in 2005 because recent technological developments has made this it is difficult to follow the earlier laws, so they have made amendment, particularly in cyber laws and electronics. So they have amended certain laws, and Copyright 1950 Act 1957, Design Act 2000, Geographical Indications of Goods Registration and Protection Act 1999, and Semiconductor Integrated Circuit is a separate area. That is in 2000, Protection of Plant Varieties and Farmers' Right Act. This was discussed in the question and answer session yesterday. and the Information Technology Act 2000. These are the acts the advocate should be familiar when they are dealing with these IP cases. Now, there is one propel your career with blogging top IP law blogs. See, there are a lot of blogs. You can go through this. HTTP blog, IP leaders, origin.com, that is where the company where I am the advisor, and IP watchdog, IP cat, spicy IP is also very good. And IP newsletters are there. Banana IP newsletters are very good. They update with latest news and managing IP. So if you make a practice to go through this, then you will understand the importance of the careers in IP. And as I said, litigation is an evergreen field. Due to dynamic nature of IP law, there is an alignment of focus of judiciary on this area. IP litigation has a wide landscape, concentrating high courts of Delhi, Mumbai, Kolkata, and Chennai. Similarly, in terms of volume, trademark litigation is the top, followed by copyright and patent. In India, there are more trademark litigation cases than copyright and patents. I'll give some examples also now. So the IP litigation in India, it's a civil, it may be a civil litigation, it may be a criminal litigation, it may be an arbitration, mostly infringement and passing off. See, if you have got a registered trademark, then it becomes trademark infringement. If it is not registered, and if the name has been there for a long time, like a generic, the court cases it can be cleared by passing off. IP audit we already discussed. So in IP audit, general audit, specific audit can be done. Usually IP audit is done as a part of the audit of the company regularly to review and evaluate the worth of its asset. As I told, if the company has got some 500 patents, every year it has to be assessed whether the patent you have filed is still the technology is available, or is it worth continuing or renewing it. See, for example, in the electronics field, in the audio system, nobody uses audio tapes or audio CDs nowadays. So if a company is having a patents on this, what is the use of renewing every year? So it is better to stop renewing that, so that you will be clearing that, and there is no point in renewing it such cases. This comes under audit, and also you have to see what are the technologies related to a particular company, and see what are the assets of a company. See, earlier the assets of a company was given as monetary assets, and also the how many people work, and also what is the skill. But nowadays the company is assessed based on the intangible assets. See, there are two types of assets. One is tangible, like your infrastructure and number of people working and all that. That is called intangible. Tangible, and intangible means it is IPR, like trademarks, patents, and all those things. So nowadays the companies are assessed based on the intangible assets. So when the general audit is taken, you have to find out what are the intangible assets, and that will help the company to progress. And specific audit is done if there is a particular litigation case or something like that. I will give one or two cases, landmark cases on IP litigations. I think most of you know about it. You must have read in your paper or some other source of information. There was Novartis versus Union of India. See, most of you know that Novartis is a company, and they are manufacturing drug. And what happened was Novartis filed an application to patent for one of its drug called Gleevec by covering it under the word invention mentioned in Section 3 of Indian Patent Act 1970. See, what is the Section 3? See, Section 3 here is here under Section 3 of Patent Act says what are the patents can be filed, what are the patents not, that we discussed yesterday, what are the inventions that cannot be patented. So under the Section 3, Novartis filed a patent that what are the patents that can be filed? It was placed, Glivac was filed under that. Now, what happens when you file a patent application? There should be some technical advancement over the earlier patents or earlier inventions. Or in the case of drugs, there should be more efficacy. That means the effect should be more in the new drug. The Supreme Court rejected their application after a 7-year-long battle by giving the following reason. Firstly, there was no invention in the new drug. As a mere discovery of existing drug, it would not become an invention. See, if you add something to a particular existing drug and if there is no efficacy or the effect on the patient or the improvement on the patient, then it is not at all an invention. Secondly, the Supreme Court upheld a view that under Indian Patent Act, for grant of pharmaceutical patents, apart from proving traditional test of novelty, inventive step and application, there is a new test of enhanced therapeutic efficacy for claims. In the case of drugs, there should be some enhanced therapeutic efficacy should be there. Otherwise, there is no point in giving patent to that. By covering incremental changes, you cannot get a patent. So this is a landmark judgment because the court looked beyond the technicalities and into the fact that attempt of such companies to evergreen their patents. That means some of the big companies, they don't want to give opportunities for smaller companies and they want to have this evergreening of patents and other people cannot access. Similarly, Britannia drags ITC to court alleging trademark infringement. This is a recent case in December 20. Britannia Industries Limited had filed 2 cases against rival ITC for alleging infringement of product packaging. That is a trademark case, trade dress actually. So you can see the similarities. If you go through the Google, you will find out what are the similarities. And similarly, Metro Shoes takes Flipkart to Bombay High Court. Metro Shoes has filed a case in Bombay High Court alleging Flipkart in selling private brand called Metronaut. See, Metronaut and Metro Shoes, when you are talking the words, it looks similar. It is called deceptively similar to Metro's eponymous brand, and also alleged that online retailer is selling shoes among other products. This is again a trademark infringement case. Deceptively similar trademarks. And similarly, there was one court case, copyright infringements, Ilayaraja versus S.P. Balasubramaniam. In 2017, Ilayaraja sued S.P. Balasubramaniam for singing his compositions without his permission. Ilayaraja sent a legal notice to SP and organizers of the concerts in different cities which he was conducting the program. And he can't perform it without the permission of Ilayaraja because the songs were created by Ilayaraja. So this was the case of copyright infringement case. But later on, I think the case was settled amicably between the two people. This is another very interesting case, copyright infringement case. See what happened, one of the photographer went to a forest and started taking photographs of the animals, and he left the camera in the selfie mode case and he left for somewhere else. So this particular monkey came and pressed that button and you got a selfie of that monkey. Now the court case, there was an organization called PETA, that is Organization for Protecting Animals. They went to the court telling this copyright belongs to the monkey and not to the photographer, because photographer wanted to make money by selling these photographs, telling monkey selfies. So the court, went to the court, the animal protection group went to the court, and finally it was decided that IPR rules and IPR laws are for human beings and not for animals. So in that way, the photographer won the case, and that's the story behind that. Now, there is one more thing you have to know about this: patent examiners. This is also one area there are a lot of opportunities as career. See here, for career opportunities are there, and patent examiners help companies to innovate and grow by granting high quality valid patents. So the patent office has taken people in different domains, engineering, science, and all that. So one can apply for this through advertisement and also looking through the website of patent offices. So just a comparison, patent related career options. There are a lot of things like patent analyst and patent valuers. And patent valuers are experts who decide the market value of the patent on the basis of various financial metrics. And licensing specialists responsible for licensing of patents, and patent LPO, legal processing outsourcing. Several LPOs are established in India. Their job is to prepare, file, and prosecute and maintain patent bringing down. Now, patent drafting specialist. This is one area, hot area where one can take up the careers. And also, as I said, teaching in IPR in colleges. So there are certain colleges nowadays, they have opened IPR cells where the IPR cell will look after the inventions brought out by the professors and also the students. And this is one area where one can become a professor and also be in charge of the IPR cells. So this all I wanted to say. Thank you for your patient hearing, and any questions I am ready to answer.
Thank you, sir.
Okay.
Yeah, any questions? Anyone can unmute themselves and ask the questions.
The forum is open for any queries in the, with respect to the career opportunities in sector. The students who are here and the staff was also here. You can come up with your queries. Yes, Gautam, it seems there are no queries. You can now take into take
sir, I have one query.
Yes.
Yeah, yeah.
I have one query. How a prior art search is possible only for Indian patents?
No. Prior art search means it is not only for Indian patents, and it should be done worldwide. I said. See, for example, if you have a new invention, if you want to get a patent, you have to do prior research not only India but also other countries. And there are several databases. For example, USPTO, European Space, and Indian, and also free patents online and all that. So before you file the patent, in order to prove your novelty, you should prove that nobody has done it. So it is a worldwide search. It is not only India. And Indian patent search can be done through the Indian patent database. There is a database, you can search for it. And there are special courses for conducting the search, and we can conduct a 3-day course for conducting such searches in any organization.
Excuse me, sir.
Yes.
I have a question, sir.
Yes.
So if a person want to protect his patent in India,
okay,
the search should be done only in India, or else the search should be done even abroad, in international level, at international level?
If before filing the patent, search should be done throughout the world. Okay. But the patent is granted territorially. See, for example, if you file a patent in India, after doing this worldwide search, the patent is granted in India, it is valid only in India. So patent granting is territorial, whereas patent searching is global.
Okay, so by this, I think if a person has, the invention is already existing in the international level, and if that is not there in India, then he cannot get the patent.
No, because it is a prior art. It's a prior art.
Okay, sir. Thank you, sir.
Okay.
I want to be able to say something, if it's okay.
Yeah, please.
Yes,
Please,
sir.
Murthy. Please, Dr. Murthy.
Yeah, I'm Dr. K.R.S. Murthy. I have been a classmate of Dr. Ramamurthy from middle school, 6th grade onwards. He was my hero. He is my hero now. He'll be my hero all the time. Even the teachers and the headmasters and madams were his fans. They used to praise him all the time. I know him throughout his career. And he's a very hardworking, gets up at 5 o'clock, whether you need it or not, and prepares. His knowledge is immense. Congratulations to him and to you guys who are taking his expertise. And, just want to make sure I mention that I'm in Silicon Valley.
Thank you, Dr. Murthy, for that inputs. Yes, indeed, it has been a very scintillating sessions for last 2 days we had with Dr. Farah, Dr. Ramurthy, and also Madam Prabhavati. They have taken the webinar to a greater level of learning. In fact, a person like me who comes from a very conventional learning, because I did my law 30 years back and has been, this IPR has been like a algebra for me all these days. But thanks to the great learning that Dr. Farah and Ramurthy sir gave us today. And in fact, I see many of the law teachers across the state have joined, and even from the other states have also joined. And we wish if Dr. Farah and Sri Ramurthy sir and if Prabhavati madam, if they are willing, we can have one offline program here at Belagavi. Belagavi is a very big city and is considered to be the second capital of Karnataka, and is a industrial hub as well. We got some top class industries and real estate developers here. We can combine with them, and even we have very good NGOs like Rotary, with which I am associated for last 30 years. We can have one offline training or workshop like that on IPR, because this is one area where I thought that not only the law students, even those people who are in industry or in entrepreneurs, they also need a lot of learning on the subject. So we hope that in the coming days we have one offline session, and since K.L.E is a big campus where we can have all the logistics here, and if you are willing, we can take the.
Yes, I'm familiar with K.L.E, and Dr. Prabhakar Kore was the founder, and I have worked with Dr. Amit Kore.
That's
and
great. That's
I have research work with them also.
That's great. That's great. That's great. Yes, sir.
Okay.
Okay, thank you, sir. Thank you, madam, for sparing your valuable time and wisdom with all of us. Okay, over to you, Ashwini. Over to you.
Thank you, sir. Thank you is the best prayer that anyone could say. Thank you expresses extreme gratitude, humility, and understanding. Now, I request Dr. Srimati Ashwini Hiremat, Assistant Professor, for vote of thanks. Over to you, ma'am.
Thank you, Gautam. Good afternoon, everyone present over here. It's a matter of pride for me to propose vote of thanks. An event like this cannot happen overnight. The wheels start rolling weeks ago. It requires planning, bird's eyes for details. I, on behalf of principal, staff, and students of B.V.Bellad Law College, Belagavi, express my deep sense of gratitude to VTPC, Government of Karnataka, and facilitator Srimati Prabhavati Rao, who gave her vital time from her busy schedule to grace this workshop and for giving phenomenal opening remarks. Ma'am, your words have completely justified the objectives of the workshop. Ma'am, I thank you for your enormous cooperation in organizing and tailoring this event. Thank you, madam. Thank you, Madam Prabhavati, madam.
Pleasure is mine. Thank you.
Yes.
Thank you, madam, for joining. Further, on behalf of B.V.Bellad Law College and VTPC, Government of Karnataka, I'd like to express our sincere thanks to Dr. Farah Deva, Madam, Associate Professor, Author, and Consultant, Bengaluru, for sensitizing the participants about the trademark and industrial design as IP tool and need to protect them. Thank you, Madam, for giving an excellent coverage on different forms of IP as well. Thank you, Madam.
Thank you for inviting me. My pleasure.
Thank you. On the same lines, I would like to thank Dr. Ramamurthy, sir, Senior Advisor, Origin IP Solutions, Bengaluru, for enlightening us on patent mechanisms and guiding our students with regard to career opportunities, especially with regard to patents and other opportunities which are available in the IPR. Sir, the sessions were very informative. Thank you, sir.
Thank you very much. Am I audible?
Yes, sir.
Yes.
Okay, I would like to thank, first of all, Prabhavati Rao, who organized this program, and also all the people who are responsible for arranging from the law college. And also I thank Dr. K.R.S. Murthy, who was my classmate, joining from Silicon Valley of US, because the timings are different. Maybe it is a night for him, but still he is able to join and give his opinion. And thank you all for your cooperation. And it was really and the questions and the feedback was really good. That will make us learn more. Thank you very much.
So I'd like to mention another thing here. Starting with Prabhavati madam, Farah madam, and Ramamurthy sir, very, very cooperative. These persons were very, very cooperative. Actually, I was scared. I was thinking whether the event happens or no, all those things. But Prabhavati madam always consoled me. She told me that don't worry, the event will happen. Don't worry, I'll arrange for you. I was very moved with her, madam. Thank you, madam. Thank you for your cooperation. A special mention to our respected principal, Dr. B. Jaisimha, for being the catalyst that stimulated us to do our best and standing as pillars of strength. Thank you, sir. I'd like to thank Jyoti madam and all my very motivating and dedicated colleagues who know their job and are result-oriented. Thank you, everyone. I thank the Master of Ceremony, Gautam Gavas, for his efforts towards anchoring. I would like to place my hearty thanks to our team of students, Karthik, Shashank, Utkarsha, Vinay, Pratima, Savita, Professor Prabhu, Vijay, for executing this event. I thank Nandan Patil for his technical support. I like to thank our non-teaching staff for their cooperation and support. I even thank all the persons who have directly or indirectly worked for this event. Last but not least, I like to thank students and participants for joining us and making this event a grand success, a successful one. Thank you one and all.
Thank you. Just would like to add here that this is just the beginning, and I would call it as an appetizer, basically whetting the appetite, as they say. And I feel that more to go, and there are more sessions which can be customized. And in particular, prior art search, which is the soul of the patenting system, is something very, very hands-on. It has to happen. So as principal rightly said, yes, we look forward to some offline sessions in the days to come, and where we can do a thorough drill down and a deep dive into how the patent search can be done, because there are many instances which Dr. Ramamurthy will share later as to how even after a search has been done, whether India or worldwide, there would be something missing. So you have to ensure that you have done a complete thorough search, whether it is from the scientific journals or from the domain, World Wide Web, and all other sources. Because there have been some very interesting cases where the patent examiners, after almost granting it, saying that this is not prior art, have revoked it, saying, hey, no, there is a prior art involved. So those cases are also there. So we have to be really careful. We have to do our job well so that we do not what is called as reinventing the wheel. So let's take it forward from here. And second thing, what I would like to give a call is, I just basically gave a flavor to geographical indications. There are many initiatives that are happening at this Government of Karnataka Center for Export Promotion, since we are the nodal agency for promotion of geographical indications as well. And the first state in the country, as I said, to come out with the policy. So my request would be, please look out in your region if there are some potential GI-able products, which we can take forward as something very potential from the region as a new GI for Karnataka. So
yes, we have here Belagavi and Shapur. We have this handloom weavers are there. They are Belagavi and Shapur sarees. Definitely we can look for this. So what you said.
Yeah, but as you would be aware that there are riders and there are criteria and all of that, we can conduct another deep dive on GIs and then give a call how academia can be part of this, because I would like to say that in a lot of my initiatives in the GI space, academia has been playing a very good role, especially when it comes to, let's say, the diagnostic studies of GI clusters. You know, in the case of a couple of them, like I remember Bidri ware, or when it was Mysore traditional paintings, Ganjifa cards, it was academia which came forward and they were part of this exercise. So I would urge you to just look into it, introspect, and see what could be, you know, taken forward as a GI product from Karnataka. Right? Thank you. That's
I wish to add, Prabhat, madam, I think few years back, when I was working as principal at Chikkodi College, Chikkodi Law College of the same society, we had the same topic on the Kolhapur Chappal, because there was a conflict between Kolhapur as well as Athani, because both were claiming geographical indication. But in fact, we have hosted that workshop there, and probably I think the matter has been resolved, because thereafter I got transferred here. Both Athani and Kolhapur were, they have both applied for geographical indication for Kolhapur.
Yes. So nothing stops any state, especially the borders, to apply as a joint application, because as you're aware, in India also, if you look at the All India GIs, Basmati is one case where you have the borders sharing it. So nothing wrong in that. And then you have Malabar pepper and couple of spices are there. Where so Kolhapuri chappals also, it's being shared between Karnataka and Maharashtra.
Yes.
So of course your Athani belt, Madhbavi region, that is where, you know, action is. And there are many families, as you know well, are actually producing Kolhapuri chappals. But there is this big topic about the Part A and Part B of GI. Like Part A meaning the GIs have been filed, but who are the producers? Are they registered? So that is a big question where we are making some efforts, and we have registered a couple of good number of authorized users. So I would again request, since you are from the region, you can motivate these producers to connect with us, and we will guide them on how to apply for authorized user, which is according to me a very simple process. There are checklists, but then pretty simple to go through, right? So thank you so much. That's from me, and look forward to more interactions.
May I request one thing? I request the organizers to please send the feedback from the participants, so that it will make us learn more.
Yes, sure.
Yeah.
Yes, sir.
Now feedback link is posted, no? I think.
It can be done.
Yes, sir. Yes, sir. Not yet, sir, but I'll request the technical person to post it.
Shall we wind up now?
Yeah.
Yes.
Yes.
Thank you,
Thank
sir.
you very much. Thank you.
Good day.
Good day.
Prabhavati madam, thank you especially.
Yeah. Thank you, Dr. Ashwini. Pleasure interacting with you. And as I said, you know, like I never do the disappearing act. I try my best to be there
It's
live.
okay, madam. I can
It's
understand.
just that, you know, right now as a state, we are, you know, into a lot of initiatives, and a lot of them are happening parallelly. Even now, when I'm talking to you, we are setting up a Google Meet. You know, this is pertaining to GI space. With Brazil, we have fixed up this B2B meetings, and we are trying to give a leg up to our exporters and artisans, how they can be part of these deliberations. So immediately I'm jumping into that. Definitely we are with you, and we will conduct a series of them going
offline
forward.
also will meet, madam.
Pardon?
Or we'll meet offline once, madam.
Yes, certainly. Please do. I invite all of you. We are in a very iconic spot here in Kasturba Road. So if anybody is coming over to Bangalore, don't miss out, because I'm sure the Visvesvaraya Museum is very popular, and we are just the next door. So we are flanked in between Yes Bank and Museum. So I invite all of you to come over.
Yes, madam. Thank you.
Thank you.
Thank you all the participants. The feedback link will be posted within a minute. Okay, you can fill it. Participants, the feedback link is already posted. You can fill the feedback. Okay, thank you.